to some things of the things, child. We got some stuff to talk about today, honey. We got some stuff to talk about. Hit that like button if you are new here. Go ahead and hit that subscribe button. We have a great time over here. You meant what you said when you said it. Really be expected, because I'll be understanding y'all sometimes. And when y'all know when I say y'all, you know I ain't talking about y'all. I'm talking about y'all. Makes me that all these people that got something to say have been actively involved in the political process in their world. I don't believe it. You ain't gonna convince me. I know y'all love me. What's up? What's up? What's up? Happy Tuesday, everybody. Come on in, come on in, come on in. Listen, I'm on a tight timeline tonight, but I wanted to come and talk to you guys about this Tyra Banks lawsuit. Now, we actually talked about the Tyra Banks lawsuit on my on the channel before. We did it during a tribe meeting, but I wanted to bring you guys a little bit more because now Tyra's attorneys have responded. So we're going to actually read through the lawsuit and read through what Tyra is actually being accused of. I mean, not being, well, yeah, being accused of. And then we're going to read through what Tyra's attorneys have filed in response. And we're just going to kind of talk about that. I have a hard stop, you guys, because I have another, we're doing the scene ATL, and I'm actually hosting. So, you know, Scotty's, well, I shouldn't say Scotty's show, the show that Scotty is on, the reality show that Scotty is on. We are doing the panel tonight. It is back. And so I am kind of on a timeline. So we're going to jump right in. We don't have time to tarry. We don't have time to tarry, as the people would say. Let me just say hi to everybody that is here. Special shout out to my members who are lit up in green. Shout out to you guys. So let's get into it. You just got finished watching. I saw that drop. I got to go watch that. I'll probably listen to that tomorrow. Maybe tonight as I'm falling asleep, and then I'll listen to the rest of it tomorrow. All right, so let's get into it. So first we're going to read what the lawsuit, the original lawsuit, and then we are going to read, like I said, the sanctions. So let me share my screen. All right, so we're going to get into it. Let me make this bigger. All right, let's see here. All right, we good? Okay, let me move this here. All right, let's get this party started. So this lawsuit was originally filed back in, let me get the date. This was originally filed, oh no, it says February the 22nd. But this must be an updated one because we already talked about this, but that's okay. Maybe this is something that's been updated. Anyway, let's just read what it is. So the introduction, it says here, oh no, wait a minute. This isn't the original lawsuit. This is, hold on. Well, let me just read through this. Let me read through this because this might give you the background that we need. Plaintiff has been granted leave to file this 4-page reply in opposition to defendant's motion for sanctions to address 4 issues raised for the first time in the defendant's reply. So again, the original lawsuit was filed in January. Okay. So it says media article supports jurisdiction and that such reliance establishes bad faith. The plaintiff's voluntary dismissal constitutes a tacit acknowledgement that his jurisdictional position lacked merit. The plaintiff multiplied proceedings by allegedly repackaging claims in a subsequently filed Superior Court action in the post-dismissal of the development. First, the plaintiff's counsel conducted a thorough and reasonable pursuant investigation before filing suit and did not rely entirely on a single. So hold on, let's read the other one first because this is the reply to what Tyra did. So let me go back a little bit. I thought this was the original lawsuit. So let me rewind a little bit. Tyra Banks signed a lease in Washington, D.C. to open up her ice cream shop. She actually opened up the shop. There was a soft opening. Remember when Kamala Harris was running for president? She took her nieces there. There was a whole thing with it. And then this lawsuit over hot ice cream. Yes. And I don't even get it. Like, what is hot ice cream? But okay. So they're saying that basically Tyra Banks signed this lease, promised to open up this business here, and basically has abandoned the business. So they are suing her based on that. So Tyra has responded and she's asking for sanctions because she's saying that basically the plaintiffs were doing the most, is to oversimplify it. So let me read you guys what her sanctions, and then that second part was the reply. Okay, because we did talk about the original lawsuit. So let me read the sanctions. Okay. Let me share my screen again. I pulled up the right one this time. My bad, y'all. I pulled up the right one this time. I never even went. Did anybody make it while it was still open? Did anybody make it over there while it was still open to find out what it is? And then she does have she said she remember on the documentary, she said that she lives in Australia now because she actually opened up one in Australia and is actually in Australia, I guess, making sure it's doing well. So anyway, let's read this. Okay, so all of this again, this is from January the 9th. Okay, so maybe this is the original. All right. So defendants motions for sanctions. Okay, introduction. Let's just read through the introduction. Hold on. Okay. Defendants and their counsel do not make this motion lightly. So that's Tyra Banks. Without circumspection, in each case they handle, undersigned counsel strive to employ zealous advocacy on behalf of their clients while maintaining professional civility and candor towards opposing parties and counsel. Moving for sanctions strains that delicate fabric of civility, and thus the undersigned are generally reluctant to do so. Nevertheless, as evidenced by the wide body of case law on sanctions, there are occasions where abusive, bad faith litigation tactics necessitate a judicial response. Unfortunately, this is one such occasion. So they said, listen, they've been doing the most. So we're gonna ask for some sanctions because they're doing too much. That's, This case should have never been filed in federal court. It arises from a garden variety commercial lease dispute involving purely state law claims. Evidently, the plaintiff, a D.C. landlord, sought to make a federal case of it because its tenant, defendant School of Smize, is part of a trending startup ice cream brand called Smize and Dream, founded by supermodel and media personality Tyra Banks. Why they acting like that's not the same person though? Why they saying like School of Smize ain't Tyra Banks? But moving right along. Conjuring spacious veil-piercing claims in a desperate attempt to sue a celebrity personality, the plaintiff commenced this action against Miss Banks, her partner Louis Martin, and School of Smiles, asserting diversity of citizenship jurisdiction as its basis for filing in this federal forum. So they're saying you overplayed your hand by putting this in federal court when it should be a state case. That's what they say. Aside from the substantive baseless of the plaintiff's claims, particularly its veil-piercing claims woven the whole cloth, this case suffered a threshold and fatal jurisdictional defect. Tyra Banks, for purposes of federal diversity jurisdiction, is stateless, since she is a U.S. citizen domiciled abroad in Australia. Ooh. Consequently, under well-established law, any case naming Ms. Banks as a party cannot proceed in federal court on the basis of diversity jurisdiction. Okay. Neither the plaintiff nor his counsel can claim ignorance of this fact. Ms. Banks has spoken publicly about her move to Australia, which was widely reported across numerous entertainment news websites many months before the plaintiff filed suit. Any reasonable pre-suit inquiry, including a remediary Google search, y'all, would have revealed Ms. Banks is a non-U.S. domicile. Remarkably, plaintiff's own complaint acknowledges Ms. Banks' relocation to Australia, yet paradoxically, plaintiffs still avert badly without any specific allegations. Oh, why they? Oh, not they gave us the definition of the word. Oh, are y'all trying to say we're not smart enough to know what the word means? That diversity jurisdiction existed and still decided to file suit in federal court. So they saying because she's right now living in Australia abroad, that they filed this case incorrectly. Okay, all right. Hoping to avoid the expense and burden of filing a motion to dismiss for the obvious lack of subject matter jurisdiction, defendants' counsel immediately raised the jurisdictional issue with plaintiffs' counsel the day after they filed the suit and asked her to dismiss the suit, even if only to refile in another forum. Plaintiffs' counsel roundly refused and even declined to provide her good faith basis for asserting diversity jurisdiction, claiming that the determination of jurisdiction would be made by the court. So they asked the plaintiff, why don't you dismiss this and refile it correctly? And the plaintiff said, nah, let the court decide. Let the court decide whether I did it right or not. Okay, interesting. Okay. Let me keep reading, honey. Left no other choice, defendants filed the motion to dismiss. Twice, the plaintiff's counsel requested extensions of time to respond to the motion, and each time the defendant's counsel consented, granting the plaintiff a total of 50 days to file its opposition. Oh, this not sounding really good for the plaintiff. 50 days? Okay. Disturbingly, the plaintiff and his counsel exploited an extra time by taking their case to the press, disseminating slanted and even false statements about the underlying lease dispute to corral public opinion against Ms. Banks and tarnish her reputation. Meanwhile, defendants waited for December 30th of 2025, the extending file deadline for the plaintiff's opposition, to finally learn what good faith grounds the plaintiff and his counsel had for filing in federal court. Yet, astonishingly, the plaintiff never did file an opposition. Instead, on the day of the twice extended opposition deadline, plaintiff's counsel voluntarily dismissed this case and refiled the complaint in a new action in D.C. Superior Court. In other words, the plaintiff and his counsel did exactly what the defendants asked them to do 2 months ago, but only after the defendant incurred the substantial costs and burdens of prepping and filing their motion to dismiss. So they did what y'all asked them to do, but y'all mad because they waited to the last minute to do it. Oh, okay, cool. Okay. Plaintiff and his counsel's conduct smacks of recklessness and bad faith. They utterly failed to conduct their legally mandated pre-suit inquiry to confirm the court had jurisdiction before filing suit. Then they compounded their errors by passing on, indeed categorically rejecting, an opportunity to cure the violation when asked by defendant's counsel at the very genesis of this action to dismiss the case and refile elsewhere. They led defendant's counsel to believe that they had a legitimate basis for invoking diversity jurisdiction and secured additional time to file an opposition, only to ultimately voluntarily dismiss the case after the defendants expended substantial resources briefing a comprehensive motion to dismiss. Child, y'all had y'all paralegals do that, but okay. In the meantime, the plaintiff and his counsel elected to begin trying their case in the media in contravention of the rules of professional conduct. As the emails between counsel suggest, plaintiff and his counsel's tactics were part of a scheme to pressure defendants into settling this matter for the high dollar demand by them. In all, plaintiff and his counsel's tactics amount to reckless and bad faith conduct, having prejudiced defendants and are sanctionable under, they cite the law, and this court's adherent powers. With cautious conviction, defendants respectfully move for the imposition of sanctions. Well, now I didn't go to nobody's law school. I didn't go to nobody's law school, okay? But it sounds to me like They waited to the last minute, but they did what y'all wanted them to do. Right? I mean, I ain't go to nobody's law school. I mean, I don't know if that's against, the rules of conduct, as they say, but I don't know. Let's read through. Okay, let's read a little bit more. So now they're going to get into the factual background. So this is going to give us the background of the original lawsuit. On April the 17th of 2024, the defendant, School of Smize, executed a lease agreement with the plaintiff to lease the property owned by the plaintiff located at 2018 7th Street, Southeast in Washington, D.C. As detailed in defendant's motion to dismiss, the School of Smize intended to utilize the property as both a flagship U.S. location for Smize and Dream ice cream brand and as a learning center for young girls to develop ground up business and entrepreneurial skills. However, due to the plaintiff's material breaches, School of Smize elected to terminate the lease and provide notice of termination to the plaintiff on September the 9th of 2024. Oh, okay. Over 1 year later, on October the 9th of 2025, the plaintiff commenced this action by filing his complaint against defendants, asserting contract, quasi-contract, and veil-piercing claims and seeking damages of over $2.8 million. As grounds for this court's jurisdiction, plaintiff boldly alleged that there is a complete diversity of citizenship between plaintiff and all defendants, without ever alleging the actual citizenship of any party. At the same time, the complaint acknowledged that Ms. Banks and Mr. Martin had moved to Australia. This acknowledgement was, of course, consistent with widely reported and publicly available internet news stories covering Ms. Banks' move to Australia, many of which were published in April of 2025, 6 months before plaintiff filed this action. As reported in those media articles, Ms. Banks had been living in Australia with her family for the past 18 months, deciding to make the move after numerous trips to the area for development of Spies and Dream business. Not that this has anything to do with the lawsuit, but why would you? Australia is the other side of the world. Like, why would you open up a store in DC and then open up a store all the way in Australia? Who was going to run both of them? I mean, why didn't you hire people? They remember we saw the ads where they were hiring people. I got questions. I mean, I'm gonna keep reading the lawsuit, but that's just interesting. That's just such a broad difference. Like Australia, that's wow. Okay, I'm gonna just keep reading. On October 10th of 2025, the day after the complaint's filing, defendants undersigned counsel reached out to plaintiff's counsel requesting a call to discuss service and jurisdiction. Counsel spoke by phone that day regarding several issues, including defendants' acceptance of service and agreement regarding defendants' time to respond to the complaint, plaintiff's desire for a settlement, and most reverently here, jurisdiction. The undersigned stressed to the plaintiff's counsel that Ms. Banks' status as a U.S. citizen domiciled abroad deemed her stateless and destroyed diversity jurisdiction. The undersigned asked if plaintiff would agree to voluntarily dismiss the case to avoid the expense of defendants having to file a motion to dismiss, emphasizing that if the plaintiff desired, it could dismiss the case without prejudice and refile in an appropriate state court. Shortly after the call, the undersigned sent the following confirmatory email to the plaintiff's counsel. And it says, "Thank you for consenting to the small extension. We will accept service. Please get back to me on jurisdiction at your earliest convenience." And then it says, "As discussed, Ms. Banks is a U.S. citizen domiciled in Australia, deeming her stateless for diversity jurisdiction purposes and thus destroying diversity jurisdiction. Please let me know if you will agree to voluntarily dismiss the case. You could refile it at an appropriate state court if you choose so." Let's look up diversity jurisdiction. Let's look that up, since that seems to be the big thing here. All right, what is diversity jurisdiction? Let's see what Google is telling us. Diversity jurisdiction is a type of U.S. federal court subject matter jurisdiction, allowing courts to hear civil cases between citizens of different states or between a U.S. citizen and a foreign nation, provided the amount of controversy exceeds $75,000. It requires complete diversity, meaning no plaintiff shares a state of citizenship with any defendant. Well, I didn't go to law school, but that seems to fit the definition. Doesn't that seem to fit the definition? Am I tripping? I mean, am I tripping? That seems like it kind of fits the definition. I mean, I didn't go to law school though, but I mean, okay. Well, let's keep reading, child. Let's keep reading. On October the 13th, plaintiff's counsel responded to the undersigned's email by emphatically refusing to voluntarily dismiss the case and by standing firm with the position that diversity jurisdiction existed, though doing so only upon information and belief as follows. It says, first, we maintain that diversity of citizenship exists in this case and venue is proper in the District Court for the District of Columbia. The court will consider numerous factors in making that determination. Upon information and belief, Ms. Banks remains domiciled in either New York or California for the purposes of diversity jurisdiction, and we reasonably expect that through discovery will support that fact. Okay, wait a minute, hold on. Ms. Banks remained domiciled in either New York. Oh, so they trying to say she was still living in New York or California for the purposes of diversity jurisdiction. I must have missed something in that definition then. Okay. That's why I don't have a law degree. Let me read this again. It says, allowing the courts to hear civil cases between citizens of different states or between a U.S. citizen and a foreign nation, provided the amount of controversy exceeds $75,000. It requires complete diversity, meaning no plaintiff shares a state of citizenship with any defendant. Okay. That's why I don't have the law degree, honey. Let me keep reading. So the plaintiff attorneys insist that the venue was proper in the district court. Okay. It says, although you may not be able to assess the good faith basis for our invocation of federal jurisdiction, fortunately, Judge Jackson is tasked with making this determination. So in other words, they said, look, you don't have to agree with me. I say tomato, you say tomato. That's what the judge is there for. That's what they said. They said, listen, it's the judge's job to make this decision. Okay. All right. Okay. Additionally, as the email exchange reflect, plaintiff's counsel repeatedly pressed defendants for a settlement offer to resolve the case, while undersigned counsel noted defendants' reluctance to navigate against plaintiffs' $2.8 million demand, and they felt had no meritorious factual or legal basis. To cajole the statement offer off defendant, plaintiff's counsel began referencing potential media exposure if a settlement could not be reached, stating in an email on October the 30th that her client had received several press inquiries regarding this case and that they were considering whether to issue a statement. I don't see anything wrong with that. Again, I didn't go to law school, but trying to get a settlement is what they're supposed to be doing, right? They're supposed to be trying to get a settlement. And to say, look, people have reached out to me because they want, media people have reached out to me because they want the story. Again, I don't see where that's out of. That's how things happen. It's Tyra Banks is a high profile person. Of course, people want to interview the plaintiff. They want the details. A week later, on November the 6th of 2025, the plaintiff's counsel wrote that she and her client intended to begin making statements to the press unless a settlement was reached, stating, "We have elected to begin responding to press inquiries next week unless the parties have begun to formalize a settlement negotiation." Again, I don't see anything. Y'all tell me if I'm tripping. I don't see anything wrong with that. If media people were reaching out and they say, look, we're going to start doing interviews if we don't reach a settlement, I don't see the problem with that. Again, didn't go to nobody's law school, but y'all can put it in there. Okay. On November the 10th, defendants filed their motion to dismiss, seeking dismissal for both lack of subject matter jurisdiction and failure to state claim. In support of that rule component of their motion, defendants highlighted, among other things, the complaint's complete failure to affirmatively allege the citizenship of any party, Ms. Banks' status as stateless person over whom federal courts have no diversity jurisdiction. Okay, so I guess if she's established as a stateless person, federal courts don't have jurisdiction. Got it. Okay. Plaintiff had 14 days, meaning until November the 24th, to respond. Twice the plaintiff's counsel asked defendant's counsel to consent to extensions, and each time defendant's counsel agreed. As a result, this court granted 2 consent motions for extensions filed by the plaintiff, collectively extending the response deadline to December the 30th and providing plaintiff a total of 50 days to prepare and file an opposition to the motion to dismiss. Plaintiff never did file the anticipated opposition. Rather, on the date of December the 30th, plaintiff voluntarily dismissed and commenced a new action against defendants in D.C. Superior Court. In other words, okay, we got it. We don't need you to reword it for us. We understand what happened. Okay, so that's what they mad about. So then they're going to tell the court why they can make these sanctions. Okay, I want to read. Hold on, let me see. I think they said that the termination letter was. I want to read the letter. Hold on, y'all. And then we're going to read their response, because now I am interested in their response, child. Sanctions are further warranted for plaintiff. Okay. So this just goes on to explain why they feel like the sanctions should happen and why the court has jurisdiction. They also want attorney's fees, which that makes sense. They want attorney's fees because they done said they wasted a whole lot of time. And then they said how much, baby, they want $38,000, honey. Look at this. They want $38,000. Okay, then. Oh, they want another $50,000 in sanctions. So they want $38,000 in legal fees and $50,000 in sanctions. My goodness. Baby, I went to the wrong line of work. All right, and there's the conclusion. I want to see if they attached. Okay, here go the exhibits, because that's what I want to find. I want to find. Okay, that's them emailing about settlement negotiations. I don't care about that. Okay, that's that. I want to see if the termination letter. That's what I want to read. Because I thought they said it was attached. I think they said it was exhibit number 4. I don't care about all these emails back and forth. We know y'all was emailing. We believe what you say happened, child. We believe what you say happened. Okay. I want to see. Okay, hold on. This is exhibit 2. Okay, they just talking about the services and the sanctions again. Exhibit 3. What's this? Okay, they breaking down the fee. Child, they are serious about these fees. Oh my goodness. Okay, that's just an itemized bill, honey. That's an itemized bill. Okay, I thought they said they attached the termination letter. Okay, that's what I want to read. Okay, now let's go back and let's read. You said that's extortion? I don't think that's extortion. I don't think that's extortion, but I hear you. I didn't go to law school, so it could be. I didn't go to law school. Oh, is this the one? Okay, so here's the plaintiff's reply. All right, this is what we were reading at first. Okay, let's go back to this. Okay, let me make this bigger. Because I want to hear what the plaintiff have to say. And the only reason why I say I don't think it's extortion is because it's what they're saying is, listen, I mean, is it extortion? Okay, I mean, but I don't think it's extortion from the point of they're not lying. They're like, look, people have reached out to us. We want to settle this case, but if we can't settle this case, then we're going to go to the press. I mean, people do it all the time. They are, okay, so y'all feel like they are trying to shake them down. Okay. Yeah, they're trying to say it's a shakedown. Yeah. But okay. I ain't go to law school. Okay. So we already read through the introduction. They're saying that they're responding to, okay. So let's read through this. So this is their response to the sanctions. They said first, plaintiff's counsel conducted a thorough and reasonable pursuit investigation before filing suit and did not rely entirely on a single news article in alleging defendant Banks' U.S. domicile. Although media coverage referenced Banks' move to Australia at the time of filing suit in this court, a reasonable inquiry did not uncover any evidence, nor have defendants provided any evidence of publicly available information stating that defendant Banks' move was indefinite and a requirement of domicile. So they were like, look, we saw the news that she moved to Australia, but that don't mean she was living there forever. We know. And we did do research. That's what they said. Defendant Banks admits she was previously domiciled in the United States. By defendant's own admission, indicated that domicile was in flux. However, for purposes of diversity jurisdiction, courts apply a presumption of continuing domicile so that domicile in one place remains until domicile in a new place is established. Because a reasonable pursuit inquiry did not uncover that defendants established a foreign domicile as required to establish statelessness for the purposes of diversity jurisdiction, plaintiff maintained a good faith belief that this court had jurisdiction over this matter at the time of filing. Now, let me say something. I have two of my really good friends. I think I've told y'all this before. Two of my really good friends have left the United States. And without getting too much into their business, there's been a whole legal situation that they've had to do to establish residency, make sure that they were going to maintain their U.S. residency, file the paperwork in the place in which they're moving to. There's a whole process. You can't just get up and leave and say, okay, I'm going to Europe, I'm going to London, and I'm going to live in London for 6 months, and that's it. In order to establish certain things legally, there's paperwork that has to be filed. You have to stay in a certain place a certain amount of time uninterrupted. Like you can't leave and come back, leave and come back. You have to, for tax purposes, there's paperwork you have to do. I mean, all of that stuff. I mean, imagine how much you have to go through if you move from one state to the next, right? So think about on a country level. So it sounds like what they're saying is, yeah, we knew she went to Australia, but we don't feel like through our research, it does not seem like she met the burden of establishing this statelessness. That's what they're saying. Now, that don't make it true, but it sounds like that's what they're saying. Okay, I just read that. Second, plaintiff has never conceded its complaint suffered from jurisdictional defects. The court granted the dismissal under rule blah, 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 without requiring any explanation from the plaintiff or its counsel. Absent such requirement, the plaintiff and his counsel are not required to disclose their litigation strategy for voluntarily dismissing the case and filing suit elsewhere. Defendants point to Weissman versus Ravlin in claiming this court sanctioned an attorney for filing a complaint which on its face disclosed a lack of diversity jurisdiction. Here, the asserted defect turns in domicile, a fact-intensive inquiry that courts repeatedly recognize as requiring evidence, intent analysis, and sometimes discovery or hearings. In Weissman, the jurisdictional defect was purely formal, facial, and undisputed. Plaintiff filed suit where one plaintiff and one defendant were both entities incorporated in Delaware. Even there, this court imposed only modest nominal sanctions. So what they're saying is the court case that you use doesn't apply. The court case does not apply. Pretty Great Eye says literally living that now. So you understand what I mean when you're moving. It's a whole process. It's a whole process. And when my friends were breaking down to me all the different things they had to do, I was like, what? Like, you don't think about those things. Like, you don't think about you hear people talk about moving out and moving to other countries all the time, but you don't think about all the things that you have to do legally to make sure you're covered if you want to come back into the United States and make sure you did everything correctly. It's a whole process. Okay. Third, The plaintiff's refiling of substantially similar claims in the D.C. Superior Court after a voluntary dismissal does not constitute multiplication of proceedings as required by 28 U.S.C. Defendants turn to GAF Corp versus Transamerica Insurance Company and claiming that defendants are entitled to reimbursement for any work product, whether it be evidence or motion papers, that was rendered useless by the dismissal of this action. Basically, they're saying you overcharging us, even if you get legal fees. The legal fees you charging us for don't have nothing to do with the dismissal. You said you worked hard on the dismissal, but you charging us for every paper clip, every staple, every copy in the copy machine. Like, you doing too much. That's what they said. You're doing too much. Defendants have filed a motion to dismiss and will now defend substantially similar claims in another court. Do not qualify as multiplication under the law. 4, plaintiff and his counsel have not violated the litigation participant speech doctrine and applicable First Amendment limitations governing trial participants' extrajudicial statements. First, not United States versus Trump. Child, not the United States versus Trump, child. Arose under a criminal jury trial and concerns prospective protective orders, not retrospective punishments. This court repeatedly stressed speech must be narrowly tailored and supported by record filings. Here, defendants highlight no particular statements imposing a significant and imminent risk to the proceedings. In short, Trump stands for judicial restraint paired with targeted intervention and extraordinary circumstances. It does not supply a general license to sanction civil litigants for the extrajudicial speech, absent a record of imminent material interference with adjudication. In other words, they have a right to talk if they want to talk to the press and tell their story. Now, this was filed on February the 22nd. Y'all, listen. Let me go back. Hold on, y'all. Let me find it. Let me see if I can find an article real quick from the original lawsuit of why she being sued. Hold on, y'all. Let me see if I can find one real quick. Because I don't know what the original ones we read before. But let me see. Tyra Banks sued by ice cream shop. So we can talk about the original. I remember what they... I just want to read our actual article. Okay, let's read through this. Okay. This is a short article because this is from the local NBC4. So, a DC landlord is suing model Tyra Banks and her partner for $2.8 million, accusing them of backing out of a 10-year lease for her ice cream shop in DC, according to court documents. Banks' ice cream company, Smiles and Dreams, started as a mobile ice cream outlet in Dubai and a prepackaged shop in Los Angeles, California, and DC. In Los Angeles, California. DC was the company's first pop-up shop, and New York will be the next to get a pop-up shop. According to lawsuit documents, Christopher Powell, a DC landlord in Eastern Market, met with Banks and her business partner, Louis Martin, in March of 2024 to open the shop in his building. On April the 17th of 2024, Martin signed a 10-year commercial lease, according to Powell's lawsuit. Powell says in the complaint that during June of 2024, the pair abandoned the building and refused to pay rent with no explanation. By this point, Powell said he undertook extensive financial investment and put in months of planning the opening while rejecting other people's applications to be tenants. So he said, look, I lost money. What up, Sodab? I lost money because I thought they was going to open up this ice cream shop. Other people wanted that space and I turned them down. A few weeks after Powell said he struggled to deal with the legal and financial fallout from their abandonment. He says he saw former Vice President Kamala Harris eating ice cream on the news at a Smiles and Dream pop-up shop a few miles away in Woodley Park. Oh, so that pop-up wasn't even at this location. Huh. Okay. Mind you, Woodley Park is on the other side of D.C. from where this location is. Eastern Market and Woodley Park are on two opposite ends of the city. Nowhere close. Not even. In June of this year, Banks opened a flagship Smiles and Dream shop in Sydney, Australia. According to the lawsuit, Powell said Banks and Martin sent a letter to him in September of 2024 saying they broke their lease because they were promised the whole building, not just part of it. Powell states in the court documents that he said only 2 retail spaces and 2 office spaces were available for rent on the bottom 3 floors. Banks and Martin filed a motion to dismiss in November. Okay. Court documents say Banks and Martin sent a formal notice of termination on September the 9th of 2024. The building had myriad mechanical, electrical, and plumbing deficiencies and were not in good working order, according to the court documents. Banks and Martin say Powell didn't respond to the notice until he sued in August of this year, according to the motion. On August the 20th of this year, Powell demanded immediate payment, according to the lawsuit. Martin and Banks sent back a letter denying any wrongdoing. In October, Powell filed the lawsuit for $2.8 million. So let's go back. Let's look at this timeline. Let's go back to this timeline. Okay. Oh, I missed the whole paragraph. The pop-up shop opened in... Okay, so hold on. Let's go back here. Okay. Let's do the timeline real quick, y'all. Let's do the timeline. In March of 2024, he met with Tyra Banks and her partner Lewis Martin. They wanted to open up a shop in his building. Now, I mean, these are his words, but it doesn't say they were going to have the whole building. It says in his building. On April the 17th of 2024, Martin signed a 10-year commercial lease. So let me say something. It would have been very specific in the lease what part of the building was going to be theirs. A 10-year lease would have been very specific that you have this lot, or this address, or this address, or this office space, or this office space. So, again, I don't have a copy of the lease, but it would have been very clear in the lease whether you had the whole building or you had parts of the building. So that's number one. All right, that's number one. So in March of 2024, no, shoot. Hold on. Shoot, I lost my timeline. Child, I lost my own timeline. Hold on. Yeah, March. Okay. April 17th of 2024, the lease was signed. April. Y'all remember April. So in April, the lease was signed. According to the plaintiff's lawsuit, he says that they abandoned the property in June. So you signed the lease in April. April, May, June. 3 months later, give or take a few days, you abandoned the property. A few weeks after that, Mr. Powell, the plaintiff, turned on the TV and he saw Tyra Banks eating hot ice cream with Kamala Harris and her nieces at a whole pop-up, a different pop-up location on the other side of Washington, D.C. So it sounds like this location never even opened. So I was thinking when we saw that pop-up shop, when I read this original lawsuit, I thought it was the same location. Come to find out, it wasn't. So Tyra Banks, you didn't even, girl, you never did, girl. Well, Quake, they said they were also going to have a school for girls for entrepreneurship, like a program So I guess that's why they said they needed more than just that for a pop-up shop. Okay. So April, the lease was signed. 3 months later, according to the complaint, they abandoned the property. A few weeks after that, they sold a pop-up shop on the other side of DC. So this is the paragraph that I missed, y'all. I don't know how I skipped this paragraph. It says the pop-up shop opened in July of 2024. Banks said her mother inspired her to open up an ice cream shop. At the time of the opening, Banks said her brother, who lived in DC for 28 years while serving in the military, inspired her to put the shop in the district. So this is where I'm confusion. So she opened up the pop-up shop at the other location in July. She didn't open it up because he said they abandoned the property in June. So in July must be the other location. And then in June of this year, a year later, she opened up her flagship Smize in Sydney, Australia. What happened to the New York location? Y'all said y'all was opening one in New York. What happened to New York? Y'all just skipped straight to Sydney? Okay. Now, according to the lawsuit, Powell said Banks and Martin sent a letter to him in September of 2024. So let's go back to our original timeline. So the lease was signed in April. According to the plaintiff, you abandoned the property in June and you weren't paying rent anymore. Because he says here that he was struggling with the legal and financial fallout from the abandonment. So I'm assuming y'all wasn't paying y'all rent, okay? So in September, y'all sent a letter to him saying they broke their lease because they were promised the whole building, not just part of it. Wait a minute. That sounds a little backwards. That's not how you break a lease. You don't send a letter after you stop paying rent saying, this is why I stopped paying rent. You send a letter. You send a letter and say, listen, our understanding, where are the other letters of communication to say, wait a minute, we were under the impression that we have free reign of this entire building. We need to have a meeting. We need to renegotiate. We need to talk about it, because if you cannot offer us the entire building, which is what we thought we were renting or leasing, then this is not going to work for us, and we need to terminate this lease. Where's that letter, Tyra Banks and your partner? Hey, where's that letter, Tyra Banks and your partner? Because it seems to me that unless you wrote a letter on the front end saying we're going to have to terminate this lease unless you can give us what we thought we were getting, you don't send no letter in September and you ain't been paying rent since June. Where they do that at? Where they do that at, Tyra? That's not how this works. Am I tripping? That is not how this works. And then you're going to tell him that you abandoned the lease because, which tells me y'all were responding to a letter he sent y'all. It sounds like that letter was in response to an inquiry that y'all already sent him. You're saying, well, we abandoned it because. It doesn't sound like that was it doesn't sound like that was a reactive, a proactive letter. That sounds like it's a reactive letter. It sounds like you're saying, oh, well, we left because we thought we were going to get the whole building and we didn't get the whole building. That's what that sounds like. But where is the letter? Hey, where's the letter explaining why y'all needed to break the lease? Where's the letter? You can't, that's not how this works. You don't just move out and stop paying rent and say, oh, well, because where's the original? See, that's why I wanted to see the original lease. which I'm sure the original lease, if they actually make it to court, we'll get it. Well, where's the original lease? Because what does the original lease say you had? Because ignorance is no defense of the law. So if y'all signed a contract and in that lease / contract, it said you have unit A, unit B, unit C, and parking lot access, you can't come back later and say, oh, well, we thought we were getting the whole building. No, because what you signed said unit A, unit B, and unit C. And I'm going to tell you why. In my opinion, again, I didn't go to nobody's law school. Y'all know I got my law degree from Law and Order University by way of Matlock College. So let's be clear. I don't have nobody's law degree. But the reason why I feel like the lease didn't say none of that is because wouldn't that be what y'all are saying in this paperwork? Why y'all arguing about whether you have jurisdiction or not? Why wouldn't y'all be saying, look, here's the lease. The lease said they were going to have access to the whole building, yet they didn't have access to the whole building. So we need to dismiss this because, and that's why they abandoned it. When you send a letter to the landlord saying, excuse me, sir, we thought we were going to get A, B, C, and D. And according to the lease says we're supposed to have access to this, and this. Yet when we showed up with our ice cream cones and our buckets of hot ice cream, which I still don't understand hot ice cream, but that's another conversation for another day. When we showed up with our ice cream cones and our hot ice cream, they told us we could only be in units A, B, and C. But you told us we was going to have the whole building. What's going on, sir? See, I didn't hear none of this. Y'all arguing about whether she live in the United States or not. And you're not even mad at the lawsuit. I mean, you are mad at the lawsuit, but you're asking for sanctions because you said they basically you saying they playing games because they drug it out and then they did drop it and then they refiled it. But again, I didn't hear any argument about the lease was wrong and he's suing. And he misrepresented himself in the lease in the negotiations. See, that's the part I don't understand. Now, I ain't nobody's lawyer. Maybe that's how it's done. Maybe you argue these things and before y'all get to court. I don't know. But it seems to me like, wouldn't that be in the argument? Okay, let's finish looking at this timeline. So in September of 2024, they sent a letter to the landlord explaining why they broke the lease. They said they were promised the whole building, not just part of it. Powell states in the court documents that he said only 2 rental spaces and 2 office spaces were available for rent. Now, he put that in his documents. He put that in his court documents where he told them what was available. But is it in the lease? See, now, Mr. Powell, who's the plaintiff, I'm looking at you now. Is it in the lease, though? See, you can say what you told them verbally, but what did y'all sign to? See, that argument goes both ways. What did you sign, sir? What did you sign? Okay. Now, according to Tyra Banks' attorney, they say that Mr. Powell didn't respond to this notice until he sued in August of 2025. Oh, wait a minute. Hold on. Let me rewind. Okay. Banks and Martin filed a motion to dismiss in November. According to court documents, the court documents say that Banks and Martin sent a formal notice of termination on September the 9th of 2024. And they said that the building had mechanical, electrical, and plumbing deficiencies, and it was not in good working order, according to the court documents. Again, see what I'm saying? Now y'all saying that the building was in bad condition. Where is well, we thought we were going to have access to the whole building. And again, you signed a 10-year lease. Y'all didn't bring an inspection, somebody in to inspect that stuff. You signed a 10-month lease on the building and you didn't inspect the electrical wiring, the plumbing. You didn't look at none of that. I mean, it's DC. These buildings are old. A lot of these buildings are old. You ain't call Ray to come down there and check the light switches and stuff. You ain't flushed the toilet a few times. See if the plumbing worked good. But again, now you're saying something totally different. Now you're saying the building wasn't in good working order. But before you said, well, we thought we had access to the whole building. Which one is it, Tyra? And again, I say, that's not how you terminate a lease. That is not how that shit works. 10-year lease, usually there's a renovation. Right. I know you didn't think it was ready to move in, ready to go. You had to know you was going to have to put some work into that building. Hello? I mean, we saw what Kenya did. Kenya did a little too much. I mean, she did a little too much. But most retail businesses, there has to be some sort of a build out. I mean, of course, you want to minimize the build out. You know, you want to minimize the build out, but there's going to be a build out. Over here by my house, it was a PetSmart. The PetSmart closed. And 2 months later, it's a Planet Fitness. Them construction workers, when I was leaving for work, they were already in that building. You know why? Because they had to redo whatever they needed to redo and renovate that space to make it into a gym versus a PetSmart. Now, I'm sure it was minimal build out because it was already a store. All you had to do was make sure all of the fixtures and all that stuff was taken out, and of course you had to paint. But you had to add a front desk area. You had to add bathrooms and make the bathrooms public. The bathrooms may or may not have been public at the PetSmart. Maybe you had to change the area where the veterinary clinic was and turn that into a locker room. There is still work that has to be done, even in a space that's already a retail space. So I don't know what was in that building before y'all decided to bring y'all ice cream in there, but I'm sure there still had to be some sort of work done. I mean, right, Kenya did too much and Tyra didn't do shit. Okay. So then they said that Mr. Powell, the plaintiff, didn't respond to that until he filed the lawsuit in August of this year. Now, Mr. Powell, I do have a question for you, sir. Why did it take you a year to file a lawsuit? If this happened in September of 2024 and they stopped paying rent in June of 2024, why you ain't filed nothing until August of 2025? I mean, were you too busy? I mean, did you have other things going on? Why take you a year? I mean, I'm just asking. I'm not saying that you're not entitled to your money. I'm just wondering what you was doing for the last 12 months. I mean, I'm sure you probably rented it out and maybe you weren't being hit in the pockets. You probably were able to rent the space out and make your money. I understand that, but why it take you a year? I'm just asking. Look, I don't know. These are just questions. These are just questions. What took you so long? Now, this my 2 cents. Tyra, I think you need to go on and pay that man. You signed a 10-year lease. It doesn't even sound like he asking for 10 years worth of rent. $2.8 million can't be 10 years worth of rent in a DC commercial space in Eastern Market. Eastern Market is that area where that space is. That's a pretty hot spot. So $2.8 million, that can't be 10 years worth of rent. It doesn't sound like that man is suing you for the whole 10 years of that lease. It sounds like he's probably just suing you for some legal fees, some inconvenience fees, and the rent over the last maybe 2-3 years worth of rent. But if you signed a 10-year lease, that don't sound like, I don't know. Let me see here. Let me ask ChatGPT. Hold on. Let me ask Chat. Let's do some math real quick. And then we're going to get off of here, child. Let's do some math. Chat. Okay, let me go into my chat. Okay. Ask anything. We're going to ask. What is the average rent on a commercial building in Eastern Market, Washington, D.C. in the year 2024. Let's see what chat tell us. Typical asking rents in Eastern Market. Okay, this isn't going to help me because you want me to do too much math. Hold on, let me scroll down a little bit. Child, they talking about per square foot. Ain't nobody, I don't know the square footage of the building. Okay. So it says office space in newer buildings, larger office space retail combination. So that's what they thought they were renting. They thought they were renting a larger office retail Oh, you know what? I could probably put the actual address in. What you think? You think if I could put the actual what you think? Hold on. Let me see if they'll give me the actual rent of that address. Go back to the lawsuit. Hold on. Let's go back to we got the address, child. We got that. Let's just do the actual address of this building. Honey, we had the address. But they said it was 218 7th Street, I think they said. Hold on. 218 7th Street, Southeast. Okay. Hold on. 218 7th Street, Southeast, DC. All right, let's see what they come up with. Okay, so they said that the average rent, they're saying that the rent is between $6,000 to $7,300. So let's do $65,000 a month. Now, here's where my math get a little sticky. Y'all help me out here. Okay, so we're going to do $6,500 a month, okay? Times 12. Times 10. Oh, well, maybe he is asking. Maybe he is asking for the whole 10 years. Never mind. I take back what I said. He asking for all of it. Never mind. But also, that's also taking into account that the rent never goes up, right? In 10 years, the rent's going to go up. In 10 years, there's got to be some allowance for that rent to go up over the next 10 years. But even if it stays at that, never mind. He right. That's about right. But I still feel like they can negotiate with him. Because at the end of the day, especially if he's already rented that space out right now, he doesn't need the whole 10 years. I mean, that's the kind of stuff you negotiate. And they said he was open to negotiations. Let me see. Let me ask chat what's in that space right now. What business is currently in that space? Let me see what's in there right now. Oh no, there is no business in that space. According to ChatGPT, it's still empty. It's listed as vacant. It's on the market for lease or for sale though. But it is marked as unoccupied. Ooh. The retail component. Oh no. The retail component is currently available for lease or sale. There are offices in that building. There are other parts of that building, but the retail part is still. So there are people in that building. There are people, and that's why he said the whole building wasn't available. Tyra, he told you the whole building wasn't available. It was people already in the building, girl. Well, thank you, ChatGPT, for your help. I'm on the vertical and horizontal, Markel. Yes, I'm on both. I'm on vertical and horizontal. They told me that I need to start doing both because that's supposed to help with your views and with your subscribers and all that stuff, child. Just trying some new stuff. Markel, I need to talk to you. You and your husband are in timeout. You are in one corner and he is in the other corner. Y'all are in timeout until I say so. Don't ask me how long. Y'all are in timeout until I tell y'all can get y'all asses out. Y'all are cutting up. Y'all are doing too much. Y'all are cutting y'all asses. Okay. Overall, in my opinion, again, don't know the law, didn't go to law school, but in my opinion, no, it says it's listed. I mean, I don't know if he's not renting it. That doesn't mean it's been occupied. That doesn't mean it's been empty this whole year. He may have had people in the retail space. I mean, I guess I can ask chat. You all want me to ask chat? Let me see. Chat is like, leave me alone. Okay, let's ask chat. Let's see. Has the retail space been occupied in the last 12 months? Let's see what chat tell us. The ground floor retail space has been vacant, listed for lease, and currently unoccupied. No active tenants. Multiple listing descriptions from early 2026 and late 2025 indicate that the retail portion remains vacant and available. Last tenant activity. Research suggests that the retail space has sat empty for an extended period of time, with reports indicating that it has not had an active retail tenant recently and that offers were made to lease it, including one mention of a prior asking rent of around $14,000 a month, but no tenant occupied the space. Who the hell offered to pay you $14,000 and why is it still empty? Now I will say that is interesting. If at one point in time he was offered $14,000 a month for this space, why is it now? Now the question is that one of the things he talked about in the lawsuit where he says, look, I was offered good money for this space, but I went with you and you left me high and dry. Maybe that's what he's talking about. He could be talking about the $14,000 that he was offered per month and he turned it down because he was in negotiation with Tyra. He said that in his lawsuit. Now let's do that math. Okay, I'm done, y'all. This is where I be going down the rabbit hole. I'm done after this. Hold on. But let's do that. Let's change the math. Let's change the math. $14,000 a month times 12 times 10. Now we have $1.6 million. That's still more than what he's asking for, but it's a little closer to what he's asking for by the time you add in legal fees and yada, 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 yada. All I'm going to say is this. It sounds to me, in my humble opinion, without a law degree, it sounds to me like either they got in that space and it wasn't what they thought it was going to be. They didn't like the space. They changed their mind, whatever the situation is. And rather than go about the proper way of breaking the lease, they just left. I don't know why they just left. I don't know why they thought that was okay to just leave. But it seems to me like in any type of rental agreement, whether it's an apartment, whether it's a car rental, whether it's, a commercial space, a retail, you don't get to just say, oh, well, it's not what I thought it was going to be, and I'm just going to stop paying rent, and I'm going to send you a letter 3 months later explaining why I stopped paying rent. Like, there's a process to break a lease. Usually there's a penalty. Okay, first month, last month, security deposit, you lose your security deposit. I mean, there's a penalty to break a lease, but generally speaking, you send a letter, you say you want to break the lease, and whatever is in the contract that you sign, whatever the lease said, about what it takes to break the lease, you just say, okay, we're going to pay that. Okay, it's going to cost us 2 months rent, plus we lose our security deposit. All right, we're going to eat that. But you don't just stop paying the rent and then disappear to Australia. That's not how that works. And the only reason why I'm sort of siding with the landlord is because they didn't bring any of that up. They're only focusing on jurisdiction and they want sanctions. Now, when they file their response, we're going to read the response. I'm going to stay on top of it because now I'm nosy and I'm curious, but I want to read the response because I want to know what is Tyra Banks' side of the story. The landlord told us his side. What's her side? I want to read the lease. What the lease say? I wonder if chat has the lease. Chat got everything else, child. The chat GPT got the lease. I never asked this much information of chat GPT off. I asked them work stuff all the time. I never asked them this kind of stuff before. Can you find a copy of the lease between this property and what's it called? Smize and Dream? What's this shit called? School of Smize. I gotta get off here in a few minutes though. But hold on. I'm just nosy now. Now my nosy juices then got going. Let me see if they can find it. Okay, they could not find a publicly available copy of the actual commercial lease agreement. They said that type of thing is typically not posted online. Well, I know, but I thought you could tell me. Oh, they said Pacer might have it. DC Recorder of Deeds. Am I that nosy? I wonder if the plaintiff, Christopher Powell, I knew a Christopher Powell. He passed away though. I wonder if the plaintiff, in his original lawsuit put a copy of the lease in the original lawsuit. Lord, I don't care. I'm Team Tyra through it all. I understand her. Let me get off of here. Now I understand her. All right, y'all, let me get off of here. Don't forget the Scene ATL panel will be the Whether You Like It or Not panel. Well, no, the panel, the Scene ATL panel. It'll be on my review channel at 8:30. So let me get off of here so I can get ready for that. But listen, me and Tracy, if you still here, girl, me and Tracy gonna stay on top of this, child. Has anyone ever had the ice cream? No. There may be a strategy in him not renting it though. I mean, of course, he's going to maximize his damages. If he lets somebody move in, then it takes away what he's lost. You can only sue for what you lost. So if that building has been sitting empty for a year, and if it's been on the market, he's showing a good faith effort to rent it out. It's not like he didn't list it. It's not like he hasn't had it listed. He's got it according to chat. It's been listed for the last year. Just ain't nobody rented it. Now, he could be doing stuff behind the scenes like jacking up the rent that nobody's going to pay or telling people no. You know what I mean? Like he could be doing stuff to sabotage anybody moving in, but he has had the property listed. So, but anyway, we're going to keep on top of this child because now I'm just nosy and I want to read the response. So we'll see what happens. The judge has to, I guess, decide about sanctions first. And since it was just refiled in DC Superior Court in January, it has to, you know how that goes. I guess, what do they usually have? Well, December the 30th, I think. However many days they usually have to file a response. So we're going to stay on top of it. We're going to stay on top of it. All right, y'all. I'll see y'all in about 30 minutes on the other channel. I will talk to y'all later. Markel, you and your husband are still in timeout. I didn't forget. Moving right along. Bye, y'all.